Welcome to The Explainer. Today, we're diving into something that affects almost all of us, the hidden rules of your job. It's this huge, complicated system, right? So we're going to break down the basic rights you have that protect you and, your money when you're at work.
Okay, let's just jump right into it with a big one. A question that I'm sure has crossed your mind at some point. Can your boss just fire you for any reason they want? The answer, well, it's not a simple yes or no, and it's in those details where all your most important protections are hiding.
So to really get that answer, we've got to start with the default setting, kind of the factory settings for most jobs here in the US. It's a legal idea called at-will employment. And trust me, it is the foundation for pretty much everything we're going to talk about today. Now, this might sound a little harsh. At will basically means that, look, unless you've got a specific contract or you're part of a union, both you and your boss can call it quits at any time, for pretty much any reason, or, get this, for no reason at all. But, and this is a huge but, at will doesn't just give your employer a blank check to do whatever they want. Sure, they might not have to give you a reason for letting you go, but they absolutely 100% cannot fire you for an illegal reason. And that little difference, that's where all your rights really kick in. So what are we talking about here? What are these protections? Well, let's start with the big two, the ones that matter every single day you clock in. Your right to be safe at work and your right to get paid fairly for the work you do. When it comes to your safety, the main player is a huge law from 1970. It created a federal agency you've definitely heard of, OSHA. These are the folks who set and enforce, thousands of safety rules for everything from how you handle equipment to the very air you breathe at your desk. Okay, but what if something does happen? What if you get hurt? That's where workers' comp comes into play. Think of it like a state-run insurance system, and the whole point is to get you help without having to go through a messy, long lawsuit. The process is pretty simple, really. You file a claim, the agency checks it out, and if it's a legit injury, you get your benefits. And what counts as being on the job can be way broader than you'd think. There's this wild case where a Coca-Cola employee got hurt at a team building event. His coworkers actually tried to throw him in a river. His claim was denied at first. They called it horseplay. But a court stepped in and said, nope, this was a required work event, so the employer is on the hook. All right, so moving on from safety, let's talk about your paycheck. It's protected by something called the Fair Labor Standards Act. This is the big one that sets the federal minimum wage, but it does a lot more. It also lays down the law on overtime pay and puts really strict limits on child labor. But what about when life happens? The big stuff. Well, since 1993, we've had the Family and Medical Leave Act, or FMLA. It's a super important safety net. For workers who qualify, it gives you up to 12 weeks of unpaid leave, but your job is protected. So you can take that time for a major family or health issue and not have to worry about losing your job over it. And FMLA is specifically for those really big moments in life. We're talking about things like the birth of a baby, if you're dealing with a serious health problem yourself, or if you need to take care of a close family member who's really sick. Okay, so everything we've covered so far has been about you, the individual. But if you look at history, one of the biggest ways workers have gained power is by teaming up. And that, of course, brings us to the whole topic of labor unions. So what is a union, really? At its core, it's just a group of workers who decide to act as a single unit. By joining forces, they get way more leverage to negotiate for things like better pay, better benefits, better working conditions, all that good stuff. And that whole process, it's called collective bargaining. The history of unions in the US is really just this epic, century-long tug of war. You have these massive laws that swing the pendulum of power one way and then another. For example, you had the Wagner Act in 1935, which gave a huge boost to unions. But then, just 12 years later, the Taft-Hartley Act came along and put a whole bunch of new restrictions on them. All right, let's switch gears and talk about one of the most important changes in American labor law ever. I'm talking about the powerful rules designed to make sure everyone gets a fair shot, no matter who they are. This is all about the fight against discrimination. Listen to this. This quote is the actual real feedback given to a woman named Ann Hopkins. She had brought in more money than any other person up for partner at her firm, and they told her she was too macho. Wow. Well, she didn't take that sitting down, and her lawsuit went all the way to the Supreme Court, completely changing the game for discrimination law. So the legal foundation for cases like Ann Hopkins is something called Title VII of the Civil Rights Act. This was passed back in 1964, and it is the cornerstone of anti-discrimination law.
It's what makes it illegal for a boss to discriminate against you because of your race, color, religion, sex, or where your family comes from.
Now, Title VII is pretty smart. It actually recognizes two different kinds of discrimination. The first one, disparate treatment, is the obvious intentional kind, like a manager straight up refusing to hire someone because of their religion. But then there's disparate impact. This is where a company has a policy that seems totally fair on the surface, but in reality, it ends up hurting a specific group of people, even if nobody meant for it to.
And you know what? Title VII was really just the starting point. Over the years, Congress added a whole bunch of other super important laws. These expanded protections to cover things like equal pay, disability, age, and pregnancy. When you put them all together, they create this really strong shield against bias at work. So, what about when it's time to move on? When a job ends. It doesn't matter if you get laid off, fired, or even if you quit. The protections don't just vanish when you walk out the door. There are actually some really important safety nets to help you during that transition. Let's quickly hit 3 of the biggest ones. First, there's COBRA. That's what lets you keep your health insurance from your old job for a while, as long as you pay for it. Then there's ERISA, which is a federal law that makes sure your retirement plan is managed properly and your savings are safe. And of course, there's unemployment, which gives you some income for a while if you get laid off. So there you have it. We've gone from that baseline idea of at-will employment all the way through this tangled web of laws that cover everything from your safety to your right to be treated fairly. These are the rules that really define the modern American workplace. But this stuff is always changing. The way we work is evolving so fast. And that leaves us with a really big question to think about. What new rights will the next generation of workers even need?